In a world where abortion is a thing, and people have the right to protest it, one woman makes a case that will go down in American history.
Hello, and welcome to Supreme Beat. On today's episode, we're going to start talking about the Supreme Court case, McCullen v. Coakley. Alright, now I'm going to turn this over to my good friend William McKinley, who will talk about some background information. Thanks, Mike. In 2007, Massachusetts passed the Selective Exclusion Act as an amendment to the Act relative to public safety of reproduction center... No, that's not right. Act relative to public safety at reproductive health care facilities. This act forbade anyone from knowingly entering or remaining on a public walkway within 35 feet from an entrance, exit, or driveway of any reproductive healthcare facility within Massachusetts. This does, of course, exclude people going to the facility for treatment, people who work at the facility, municipal people, like firemen and police officers, and people who are just trying to get to the other side of the street. Now we're going to turn it over to my twin brother, Bill Clinton, over there, who's going to talk about the questions of the case. Bill? Thanks, Tom. Our questions here today are whether the Massachusetts law abides by the First and the 14th Amendments, and whether the prior decision in Hill v. Colorado should be limited, or should be put up for review and limited if this Massachusetts law pertains to it. Thanks, Bill Squared. Now I'd like to give it over to our correspondent from the Daily Planet, Lois Lane, who's going to talk a little bit about Hill v. Colorado, the precedent in this case. Lois? Thanks, Mike. Back in 2000, Colorado passed a law that set up a 100-foot zone. Within that zone, there was an 8-foot floater zone in which people could not approach those trying to attend the abortion clinic. But if the abortionee allowed, they would be able to approach them and speak to them about other methods besides abortion. The Supreme Court ultimately decided to uphold the Colorado law under the question of whether a law targeted at protest, education, and counseling can be content neutral, or whether such a law necessarily demands that speech be categorized based on the message it conveys. Thanks, Lois. Now, I bet you're all wondering, well, Mike, that's great, but what does any of this have to do with the Supreme Court case? Well, I'm about to tell you. Remember that Selective Exclusion Act I mentioned earlier? Well, there were some people who weren't too happy about it, mainly protesters. Sweet old Eleanor McCullen, and others like her, sought to reach women who were contemplating abortion to help give them information on other methods, and help them pursue those methods if they so please. With this new Selective Exclusion Act in play, they were unable to do so. So what else could they do but go to court? They brought their case to the District Court of Massachusetts, saying that they had a First Amendment and 14th Amendment right to peacefully protest. The District Court and the Court of Appeals for the First Circuit both sided with the Massachusetts law in this case. Now it's still up for the Supreme Court to decide. Hopefully we'll have an answer by June. Now take it away, Mike. Here at Supreme Beat, we like to formulate our own opinions before the Supreme Court does. And now we're going to tell you, the viewer, what it is. This time, we're siding with the petitioners, like Miss Eleanor McCullen, who said that this law is illegal. The Selective Exclusion Act is not content neutral, and specifically targets certain people. Mainly petitioners. Massachusetts specifically singles out those trying to get an abortion as the sole benefactor of this law, and prohibits any obstruction, even if it's just peaceful protesting outside the abortion clinic. The state says it wants to create an area free from violence and obstruction, but it only applies to abortion clinics, but no other buildings in the state. What's up with that? The act is also not viewpoint neutral. It allows for any employees of the abortion clinic to speak to the abortionee, while excluding anybody else from speaking to them. Any speech by an employee will express the views of the clinic. Right here, the Massachusetts government is giving one side an exemption from speech regulation. This gives them an advantage in expressing their views to the public. In their decision, the First Court of Appeals decided that speech was not in fact being regulated, but the area in which it could occur was. But with a 35-foot zone, that's all a bunch of hooey. In a prior case, Rosenberger v. Rector, the Supreme Court decided that government regulation cannot favor one side over the other in private speech. The government cannot grant the use of public forum to people whose views they find acceptable, but deny it to others who they do not find acceptable. This act makes it clear that Massachusetts is favoring clinic workers over petitioners in their use of the public walkway. With all that being said, we here at Supreme Beat don't think that this is a means for repealing Hill. Comparing the two cases, Hill is much broader and encompasses protesting outside all medical facilities, not just abortion clinics. The Colorado law in question in the Hill case also set up a floating zone in which welcomed approaches from protesters were allowed if the abortionee so chooses to let them in. This law doesn't let any petitioners within 35 feet of the abortion clinic, even if the person trying to get an abortion allows them. Here we are out in the streets for a new segment I like to call Street Justice.
Street Justice.
Where we go around and ask people, random people, questions about the Supreme Court case.
Street Justice.
Excuse me. How do you think the Supreme Court should decide in McCullen v. Coakley?
I don't know what that is.
Okay, it's good.
Street Justice.
Well, there you have it, folks. Now it's time to hear what you think. I have a few questions for you. Number 1. If the court decides in favor of Coakley, what do you think the future of abortion laws and laws pertaining to outside regulation of abortion clinics will entail? And 2, if the zone outside the abortion clinic was less than 35 feet, say around 8 feet, like it was in Hill v. Colorado, do you think this case would even be present at the Supreme Court? Make sure you text your answers to 35402. Thanks. Before we sign off, we want to make sure that everyone at home knows we are not trying to limit a woman's rights to abortion. We are just trying to give our opinion on the laws in question. Oh, and I'm not in the shop. Wait, no. People going to the facility, people working at the facility, municipal people like police, and people trying to get to the other side of the street. Alright.
It's still going.
Oh. Within that zone, there was an 8-foot radius buffers or floater zone. Okay. Abortionee, is that a word?
Okay.
Just trying to get in the way. Okay.
Yeah.
Let's see. Are you still good?
Yes.
The Supreme Court ultimately decided. Number 1. If the court decides in favor of Coakley, what do you think this, and 2. If the area, no. Sweet old Eleanor McCullen and others like her sought to they brought their case to the District Court of Massachusetts, saying that I already forgot what I was going to say. This is really bad, this.
Okay.
The state said...
Good.
The act is also not... But with a 35-foot zone, that's all a bunch of hooey. In a prior case, Rosenberger v. Rector, the Supreme Court set up a floating zone in which welcomed approaches from protesters were allowed if the abortionee
Allowed. Go. Good. Good.